Good morning, everybody, and welcome to today's presentation on Safe Harbour. My name is Shaun McKinnon, and I'm from BDO and a partner here in the Brisbane office in our advisory practice. And joining me today will be two of my colleagues from Sydney and Melbourne. So we'll have Duncan Clubb from our advisory practice in Sydney, and Mathew Blum, who is an associate director in our advisory practice out of Melbourne. So today's session, as I've already identified, is Safe Harbour, and it's quite topical given the COVID protections that are currently in place are due to expire at the end of December. So it's a good time for us to recap on what those provisions are, and then look at Safe Harbour in practice and understand what it looks like post-December. So what we're going to cover today, we're going to talk about exactly what Safe Harbour is. So the standard version of Safe Harbour is very different than what's been available in the COVID provisions recently. Then we're going to take you through what those COVID provisions are. We're going to look at what they are and what's changing in relation to them. And then we're going to talk about some of the risks that you'll need to consider as directors when we come up to the end of those provisions. We'll then walk you through some Safe Harbour in practice. We'll talk about how Safe Harbour actually drives positive restructuring efforts. And then we're going to look at where the market is at the moment, give you a little bit of market intel around what we've been seeing. And then we'll finish off by taking you through a few sort of FAQs that we get all the time in relation to Safe Harbour before we wrap up. So look, that being the case, we might get straight into it, and I will hand over to Duncan, who's going to lead us through the first section.
Thanks, Shaun. Morning, everybody. Duncan Clubb from the BDO Sydney office here. Safe Harbour is still a relatively new piece of legislation. It was introduced in September 2017. It was primarily designed to encourage, I guess, a bit of a business rescue culture by giving directors sort of protection from that civil liability around insolvent trading. Australia's laws for directors around insolvent trading are some of the most onerous in the world. And the penalties if you get done for insolvent trading are actually quite severe. And so I guess the purpose of the legislation was to address the fact that it was a very risk-averse piece of legislation from a director's perspective. It sort of encouraged people to put the company into administration at the first sign of trouble, as opposed to trying to work through the issues and rescue that business. So we've sort of got a twofold purpose. Basically, it gives the directors the chance to protect themselves, and secondly, to preserve the business, preserve enterprise value, and basically keep the company going. So that's really the background to the legislation. The jury's probably out as to whether it's been effective and whether it's achieved its purpose. There's no statistics available as to how many companies avail themselves of Safe Harbour. We'll touch on it later, but it's not something that you really need to disclose. So there's nobody really knows how much it is being used. It's never been tested in court, so people don't. We just don't know. Firms like ours and our competitors, we've done a reasonable number of them, but it's impossible to tell whether there's a material take up of the legislation or not. But if it's ever going to be relevant, the next 6 months as we go into the post-COVID protection is when it will really come to the fore and hopefully achieve the purpose that the legislation was designed to do. If we flick onto the next slide, Shaun, insolvent trading is basically when a company is unable to pay its debts as and when they fall due. Pursuant to Section 588G, directors have got a duty to prevent insolvent trading. Now, insolvent trading actions are rare in Australia. They're very difficult to prove. It's not a simple process, but there remains the risk for directors that they can be held personally liable for the debts that have been incurred once that company has become insolvent. As you can see on that last bullet point there's material civil fines and criminal penalties which can apply. So it's not something that to be taken lightly, and as I said, it comes back to the rules for insolvent trading for directors in Australia being some of the most onerous in the world and really not encouraging a rescue culture, and that's what Safe Harbour is designed to address. So the legislation as it's designed is basically to promote that rescue culture, and there are a couple of things that need to be considered. If you decide, make the decision that you want to enter into safe harbour to take that protection from insolvent trading and develop a restructuring plan, there's a couple of criteria that you need to meet. The most practical of which are that your employee entitlements need to be up to date, and they need to be continued to be up to date throughout that safe harbour process, and that includes superannuation. Similarly, the ATO lodgements need to be up to date. You don't have to pay, but you need to be up to date with your BASs and your PAYG and that sort of thing. And that needs to be at the time you enter into safe harbour and throughout the process. And I guess the last precondition is that any debts that you incur during that process need to be for the purpose of your restructure and your turnaround plan. So if you incur debts through your company which are not associated with the turnaround, then that protection, the safe harbour protection, won't apply to those debts. Okay, so the requirements that once you make the decision that you might be at risk of insolvency either now or in the future, and you want to develop a safe harbour plan, you need to develop a plan which is reasonably likely to deliver a better outcome for the creditors of the company. So that doesn't mean that it's going to return you to solvency, but it means that it will deliver a better outcome than putting the company into a liquidation would otherwise deliver. And so that's where that point around preserving enterprise value becomes relevant. So that if you can preserve enterprise value by way of trading on, and that enterprise value will be worth more than just liquidating the company, that's the grounds for basically entering into safe harbour and having a shot at a turnaround. So to do this, you need to, as a director, be properly informed as to the company's financial position. You need to make steps to make sure that your employees and officers are not acting inappropriately, and that would have, in terms of the ability of the company to pay debts. So you can't just not pay debts, is I guess what that's alluding to. You've got to make sure that your financial records are up to date. You have to take advice from an appropriately qualified entity. Now, this is a bit of a vague one, but typically it means either a liquidator or a experienced insolvency lawyer. That's typically what that means around an appropriately qualified entity. And you have to have a plan or start developing a plan which is going to deliver that better outcome for creditors. The process it has to be signed off by that qualified independent advisor, which I was alluding to before, be typically a liquidator or a lawyer who works in the liquidation space, so an insolvency lawyer. And that person will look at the plan, they will challenge the plan and basically give the board guidance as to whether or not that better outcome is likely. Things to consider is obviously whether you think you're insolvent either now or you will be in the future, and whether you therefore need to develop this plan. You have to engage that restructuring professional to assess the plan. You need to make sure that you've met the preconditions for safe harbour, being the employee entitlements and the tax lodgements. You need to develop that turnaround plan and have the restructuring professional assess the outcomes, the better outcome test. Then you need to make sure that you continue to comply with the requirements of safe harbour. So you need to work through your turnaround plan. You need to continue to make your employee obligations, meet your employee obligations and make your tax lodgements. And then, all going well, you exit safe harbour when the plan has been achieved. Alternatively, you exit safe harbour when the plan is no longer working and it's determined that it's not going to deliver a better outcome. You'll also exit the plan if you make the decision to put the business into administration or liquidation, and it will cease at that date. So that's, I guess, a bit of a background to safe harbour and the process. Now that legislation was relevant up until the 25th of March this year, but on the 25th of March, the government announced temporary safe harbour relief for all directors. So it was basically a blanket protection for everybody to protect people from that insolvent trading liability that we mentioned to start with. Now this protection is going to cease on the 31st of December. So the temporary protection, which everyone has been enjoying for the last, well, essentially 9 months, basically means that if you've been trading, if you've been impacted by COVID, that's pretty much it. there's no real criteria. You don't have to meet any of those obligations that we mentioned in the safe harbour section I just talked through. So everybody's enjoyed it, but come the end of December, we're back to that safe harbour legislation becoming relevant again, because that protection will cease, and this is the important thing to recognise, I think. And there's a little bit of uncertainty as to how you enjoy that protection. So there's a couple of industry bodies who sort of work in the liquidation insolvency space, which have taken differing views on how a director will take advantage of that COVID protection. So the ARETA view is quite conservative, and it's gone through the legislation and it's decided that basically, if you want to take protection, avail yourself of the insolvent trading protection through the COVID measures, you need to have your business in administration by the 31st of December. Otherwise, on the 1st of January, you'll continue to be trading on, and you'll become liable, and you will have lost that COVID protection. Now, the TMA, which is another organisation that works in the restructuring and turnaround space, has taken a differing view, and they've said that that's not the purpose of the legislation, and that they don't see that you need to be in administration before the interim period expires on the 31st of December. I guess the message here is that it's completely untested and nobody knows what's going to happen. So the conservative thing to do would be either you take the TMA view and you put yourself into administration. Seems a little bit drastic, given that the purpose of the legislation was to get everyone through this virus period. Or B, you acknowledge that your interim measures have ended at the end of December, but if you've got concerns around the viability of business going forwards, that would be the time to enter into a safe harbour plan. So you say, right, 31st of December, the interim measures have ended, but on the 1st of January, here's my safe harbour plan, and I'm going to work through this for the next however long to preserve that enterprise value to rescue this business. And that's, I guess, really the whole point of this session today, is to give people, get people up to speed on how to protect their business, how to protect their personal liability during 2021. And so with that, there's another little interesting point that the government has come out and said, from the 1st of January, there'll be some new restructuring laws for insolvent companies to come into effect from the 1st of January, and that these laws will coincide with the end of the temporary safe harbour measures. These laws are basically aimed at small businesses, i.e. with debts of less than $1 million, including the tax office. It basically allows the director to remain in control of the company, and therefore let the business restructure and survive, whilst creditors are basically sort of dealt with almost informally, but with the protection of a sort of legislative mechanism. Now the challenge, I guess, is that typically what we have seen is that the businesses that avail themselves of safe harbour traditionally have been your larger businesses where they've got independent board members, they're either listed or they've got debts materially more than $1 million. So I just don't know that the insolvency laws that have been introduced from the 1st of January are necessarily going to capture the same people who need to be relying on the safe harbour provisions and safe harbour protection that has been available up until the end of December. So that's, I guess, a challenge. And again, we are recommending for our clients that 1st of January onwards, if you've got concerns about solvency, you shouldn't be thinking, well, this legislation is going to solve my problem and let me preserve my business, because the vast majority just don't qualify, purely because of the issue of the size of debt. And on that basis, we're saying safe harbour is going to deliver you a better outcome. So on that basis, on that point, I'm finished, and I'm going to hand over to Shaun, who's going to talk you through some of the practicalities.
Thanks, Duncan. All right, so Duncan's talked us through obviously what is safe harbour, and he's talked us through some of those COVID protections, and he's already highlighted the fact that the government's provided protection under COVID that runs up until the end of December. They've identified some new legislation which is going to take effect from the 1st of January, and that's a pretty good indication, we think, that they're not going to extend any more insolvent trading or safe harbour protections post that. Now, most of the people on this conference call today are company directors or advisors of businesses that in most cases probably won't be covered by the new restructuring laws for the small businesses. So they'll have to revert back to what the original safe harbour process looks like. And so that's what I'm going to take you through now. So safe harbour in practice. First of all, let's talk about actually entering safe harbour. Now, Duncan alluded to some of the requirements earlier, but effectively the first step is identifying that there's some sort of solvency issue. Now, the board would typically consider their solvency position, and once they've decided that there is in fact an issue, they would determine that they have to enter safe harbour. Now, once you begin developing or implementing a course of action, that from that time you're effectively in safe harbour. Now, some of the things you need to consider about entering into it, obviously we need to consider the preconditions. So if your employee entitlements aren't paid up to date, or your ATO lodgements aren't lodged up to date, then you won't be eligible for safe harbour and you can't enter it, you can't get that protection as directors. But provided you do meet those preconditions, the board, in our view, should formally resolve to enter into safe harbour. That should be documented in the minutes of board meetings, including file notes, and then any records of advice that might be received around that. And the sort of advice that we're talking about there are probably, it's not uncommon for boards to consider external advice around understanding their current solvency risk as a starting point. Now, one of the other things that you should consider if you're entering into safe harbour is just have a look at the relevant directors and officers policies that are supporting you as directors, and make sure that any notification or disclosure obligations in those are followed to make sure that they continue to stay in effect. But effectively, the process of entering safe harbour is understand whether or not you have a risk, understand if you actually satisfy the preconditions and you can qualify, and then take steps to formally enter safe harbour. And just starting or beginning to develop or implement that course of action is in fact enough to put you in safe harbour and start the protection. Now, it doesn't end there. You've got to, within a reasonable amount of time, start to move forward to develop your plan. I'll talk about that next. So you've made a decision as directors to formally enter into safe harbour. Now what you've got to do is develop a formal restructuring plan that is reasonably likely to lead to a better outcome than insolvency. So let's talk about what that particular plan looks like. So the legislation isn't prescriptive, but the sort of things that safe harbour engagements that we've conducted would typically involve would be the following, and I'll talk you through them. First of all, you have to obviously deal with all of your key creditors. So understanding what the negotiation is with those key creditors as part of your plan, what do you require to do to make sure that you can get the position of the company into a better outcome than insolvency, would typically involve negotiating either standstill agreements, a renegotiation of payment terms, which is pretty common during the COVID period, whether or not you actually need to renegotiate the underlying supply agreements themselves, and in some circumstances, even negotiating haircuts, as in a reduction of the debt owing to people, simply because in circumstances where you can't get that reduction, you can't move forward. And we've seen a lot of that specifically around landlords. Obviously, the tenant and landlord code of conduct that was implemented by the federal government and then later developed through each of the state governments provided for, in circumstances where you're impacted due to COVID, for reductions in actually the amount of rent that you had to pay. The other thing that we would see in any restructuring plan is obviously how you're going to deal with your financiers. They're a key stakeholder in any sort of restructure. And being able to demonstrate that you're engaging with them early and that you're getting their support is a critical part of any plan. Now, for me, the most important part and the core of any restructuring plan that you're going to need to rely on for safe harbour is, of course, the underlying financial forecasts that support that. Now, ideally, they would be a three-way profit and loss, balance sheet, and cash flow forecast. And most importantly, they need to identify that you can hopefully trade through on a cash flow positive basis. Now, that may mean that you need to renegotiate some of your creditor terms until such time as your operating conditions improve. It may be that you can permanently renegotiate some of your trading terms or some of your liabilities to put you in a solvent position. And in the interim, while you're negotiating that, you rely on your safe harbour. But your financial forecasts have to demonstrate exactly what steps you're going to take, and then put those into numbers so that you can demonstrate that the course of action that you are taking is reasonably likely to lead to a better outcome than letting the company go into either administration or liquidation. And one of the questions that we've asked a lot around those restructuring plans, where we've talked to people about it over the last few months, is how do we deal with the uncertainty around COVID-19, and in particular, how that impacts our trading forecasts going forward. And look, all we've suggested in those circumstances is that all you can do is forecast based on the most readily available information that you can determine in the current environment. And if you've got a reasonable basis for the assumptions supporting the forecast, and they will necessarily be a little bit subjective around some of your COVID trading conditions, then I think that'll be reasonable in the context. Now, the other side of a restructuring plan that's pretty important is obviously a financial analysis to understand whether or not this particular action is reasonably likely to lead to a better outcome than a liquidation or an administration. So in some of the plans that we've looked at, the first thing that we do is work out whether or not, if there's a concern around solvency, we look at the position as to whether or not, if the company went into liquidation or administration today, would the creditors receive 100 cents in the dollar, and if not, what would that be? And that's, I guess, the benchmark that you've got to try and beat by demonstrating your restructuring plan will lead to a better outcome than that. Now, once you've actually understood all the different financial metrics, there'll obviously be a series of measures and milestones in that particular restructuring plan, which you need to be able to meet, and that you need to be able to demonstrate actually achieve what you're trying to achieve. And they should be part of your plan as well. Now, you'll need to be constantly reassessing against the actual results to ensure that this particular plan remains valid, and that includes obviously the forecasts that support it. And then outside of that, you need to be constantly monitoring the preconditions to ensure that you continue to enjoy the eligibility for safe harbour. So those preconditions obviously are number one, that your employee entitlements are up to date, number two, that your ATO lodgements are up to date, and then obviously, as Duncan alluded to earlier, that you're incurring debts that are part of, effectively for the purpose of the restructuring plan. And that usually does include any sort of debts in the ordinary course of business. But it's important to know that as directors, that you're only protected while those preconditions are met. So if during the period of safe harbour, and safe harbour can actually run for an extended period of time, there's no prescription in the legislation that says it has to end after a certain period. It could foreseeably last for potentially 12 months or more. But if in that period you fall behind in your employee entitlements, or you're not lodging your ATO lodgements in place, then it's important for you to remember that your safe harbour protection will no longer exist. Now, you've developed a plan. Another important part of the legislation is that you have to go to an appropriately qualified entity, engage them to give advice on the plan. And that entity or person needs to be able to sign off on the better outcome test that we've talked about. The better outcome test obviously is that the plan is reasonably likely to lead to a better outcome than either administration or liquidation. So a couple of things, I guess, is first of all, who can be that advisor? Well, the legislation actually isn't prescriptive. It just says an appropriately qualified entity. But if you look at some of the explanatory memorandums, and the Australian Institute of Company Directors have also issued some guidance on what they think it should be. And most of that talks to somebody that is, first of all, appropriately qualified in that field, that has professional or educational qualifications that are required to be able to give this type of advice. Typically that they are a member of a professional body that has a relevant code of conduct around professional standards. These are the sort of things that you should consider, and they're more relevant as you start to deal with more complex and larger businesses based on most of the AICD advice that they provided. In short though, the sort of people that would typically be those that could provide advice around the plan are either going to be accountants or lawyers that are qualified in the area of restructuring. Now, some of the things that you're going to need to give that advisor is evidence of your negotiations with creditors and financiers. So for us, in the ones that we've looked at, it's not enough to just give us a document that says, this is what we're going to do. Here are the inflows and here are the outflows, and this is the way we're going to renegotiate with our creditors and our financiers. You have to demonstrate that those are real. You have to be able to give documentary evidence to support all those assumptions and the fact that you're actually able to achieve them. Because for you as a director, if you're in a position where you need to rely on this safe harbour protection later on, then it's really going to be critical that you have documented processes and information that is relevant to be able to ensure that you can rely on the fact that all of the things you put in your plan were reasonable. Now, measures and milestones within the plan, they're going to need to be reviewed in order to determine if they are realistic. So let's say, for example, that you provide that your plan will give your secured creditor a payment of X in 6 months. So your major bank, you're going to give them a payment of X as part of some sort of agreement to renegotiate your terms. You need to be able to demonstrate that you're going to be able to meet those terms. It's not good enough just to be able to say, hey, we're going to do this and push the can down the road if the underlying requirements from a cash flow perspective can't be demonstrated. Now, once the advisor has gone through all of the assumptions in quite a bit of detail, they've looked at your milestones and whether they're achievable, they then have to sign off on whether it's reasonably likely to lead to a better outcome. And once you pass that hurdle, you continue to be within safe harbour. Now, our view is once you've actually got the sign off from your independent advisor, is that the board should formally adopt the plan. It's important to document the plan and the board's decision and why. And you should record advice in the minutes of company meetings that the advisor has signed off on the better outcome test. Now, from our perspective, as Duncan's talked about earlier, there's not been any tests on safe harbour defence yet. Nobody's actually had to rely on it. But from our perspective, the more documentation you can put in place as directors, the better. Now, I guess you've got to keep in mind that this protection is not for the company, it's for you as directors. And so we sometimes get the question as, why do I need to put this through the board minutes, etc. Well, as I said before, safe harbour hasn't been tested. It's not prescriptive whether or not you need to put this through the board minutes. And in fact, some advisors might suggest that you do it outside of those. But our view is that if you need to rely on this, it's going to be in circumstances where at some point in the future, a liquidator has decided to pursue you for insolvent trading. And that liquidator is obviously going to have access to all of the company's books and records. And if it is quite clear and evident in the documentation that exists within those companies' books and records that you have been subject to safe harbour protection, it was a robust process, and that the safe harbour protection was genuine, then I think it's unlikely that a liquidator is going to pursue you in the first place. So the more documentation, the better, is our view. Now, once you've actually adopted the plan, that's not the end of things. You've got to move to implement the plan and make sure it's a live document with ongoing monitoring. In particular, while the COVID-19 situation remains fluid, which is one of the reasons that a lot of businesses and the directors are currently talking about safe harbour when they wouldn't have been 12 months ago. So some of the things you've got to consider as you move forward. First of all, debt should be incurred only if they are directly or indirectly related to the plan. So this is generally considered to include any debts that are normal part of business, but anything that's outside of the normal part of business or outside of the plan that you're involved in, then they shouldn't be incurred. So let's say, for example, that you've decided that a particular business division needs to be dropped, or a particular line of supply needs to be dropped. Then obviously costs associated with those sides of the plan should be stopped, and potentially any debts you incurred in relation to things like that wouldn't be covered by your safe harbour protection. The implementation should be documented. Steps you took to implement the plan, negotiations you had, meetings with creditors, meetings with other stakeholders, meetings with capital providers, all this stuff should be documented so that you can rely on it as directors. You clearly need to monitor the actual results against any forecasts that sit within your plan and make sure that you're achieving those. Continually update the plan as things change and ensure that the better outcome advice remains valid. Now that might involve you actually going back to your advisor multiple times to get them to sign off on whether or not the better outcome test is still passed. In the safe harbour engagements that we've seen at BDO, there's a real range as to how they operate. At one end of the spectrum, we get asked to review a plan, sign off on it as being reasonably likely to lead to a better outcome, and then we effectively have little input after that. So really those, from my perspective, are directors looking for a bit of a tick the box, okay, we're okay for now, And they typically move forward on the basis if they keep meeting that plan, they're covered. Now, on the other end of the spectrum, we've had other engagements that we've been involved in where we're actually regularly involved not only in developing the plan, but in actually helping the implementation of it. So we're sitting in board meetings on a regular basis. We're continually providing updates to ensure that the directors know that they're continually covered by Safe Harbour. We're continually assessing the issues that relate to the Safe Harbour plan to make sure that all the preconditions and the requirements are being met to give the directors protection. It's up to you as directors to determine which of the two ends of the spectrum are relevant for you. But typically, it's important that you continue to make sure that that better outcome advice remains valid. And look, the other thing that I'll just touch on briefly is just to say that be prepared to update and shift strategy if required as the environment evolves. I guess as we move through to 2021, in some industries in particular, trading environments continue to be a little bit uncertain. You can continue to be protected by Safe Harbour, but you have to be agile and you have to continue to update your position and the advice to make sure that you're still covered. And staying in Safe Harbour, look, once the plan is in effect and it's signed off by your appropriately qualified advisor, it's important to continue to monitor the plan as well as ensure that certain things are being done by the directors and the board to make sure that they continue to qualify. Now, we've talked about ATO lodgements being up to date. We've talked about employment entitlements being paid on time. The other things that the legislation talks about that directors need to be doing is obviously to keep themselves informed of the company's financial position at all times, to take steps to prevent officer misconduct that may impact the ability to pay debts, and make sure the company is keeping appropriate financial records. So these are some catch-alls that need to be dealt with all the time. So look, that sort of brings that section to a close. I hope I've given a little bit of insight as to how Safe Harbour would look in practice for you directors and advisors on the call. I'm now going to hand over to Matthew, who's going to take us through the next section of our presentation. So Matthew, over to you.
Thanks, Sean. Hello, everyone. Mathew Blum from our BDO's Melbourne office. Pleased to join Sean and Duncan to talk about this very topical issue. My background is purely in the insolvency and restructuring space, so this is it's definitely a highly relevant topic to myself. So we'll share some insights with my experience. So if Sean, you can jump to the next slide. So does Safe Harbour support restructuring efforts? Absolutely, it's a core element of the regime. And I'll talk to some statistics that have been gathered by ASIC over the years that support that as well. So these statistics, which you've got up on your screen there, this little Manhattan chart, talks about reasons that companies fail. So basically what we're getting is the benefit of other people's hindsight. And then it's a matter of making sure that we don't make the same mistakes. So I'll drill down on a few of the different reasons that companies have failed in the past and how that relates to Safe Harbour. As you can see, each year, a little bit of a pattern forming. They haven't released the most recent year, but you can tell what the trend is in most cases. So inadequate cash flow or high cash use year after year is listed as the #1 cause of company failure. Now, to me, that in the majority of cases is actually more of a symptom than a cause. So if you look at some of these other reasons of why companies fail, it helps justify that. So for instance, poor accounts receivable management will naturally manifest itself in a cash flow issue, or continued trading losses will eventually put a strain on the asset position. So even though that's the #1 reason, it stands to say that, well, it might be worth scratching below the surface and then looking at some of the other reasons why companies fall over. So going to the next most common reason, you can see that poor strategic management is just about as prevalent as poor cash flow. So and to me, what that says is that these situations could have perhaps been avoided if the matter was managed slightly differently. So And then if we jump over 2 columns to the right, you can see that poor economic conditions over the last few years has been fading away, which I think it would be safe to say that that will be changing this year. And so what that will do is just put a bit more stress on these other reasons. So the reason why I talk about this in the context of a safe harbour restructure is because, well, if a safe harbour was adopted, it stands to say in many instances that if a business had assistance with their strategic management, then based on these ASIC numbers, then a corporate liquidation or administration could have been avoided. And what makes it a little bit more of a crime is that, well, it's controllable. And so aside from the protection that a director's afforded, their personal asset position being protected while they lead a company through a restructure, it can actually help the position of the company, help it recover in a turnaround situation. Jump to the next slide, Sean. These are some other statistics that I've pulled from the Australian Bureau of Statistics website, so the ABS, and which again further support that safe harbour can help a business that may in fact be struggling despite the economic conditions. So, sorry, excuse me. With a subject matter expert, they can often help a director who they're not familiar with being in this situation of financial distress. More often than not, the people that we're assisting, they're good at what they do. They're good at their trade or the nature of their business. They naturally haven't had the level of experience that Sean, Duncan, and I would have had with dealing with financial distress and how to navigate through that. And so looking at what the Australian Bureau of Statistics have compiled really supports that. So it's probably no secret that a lot of businesses, their revenue's been adversely impacted. So in July and October, you can see that it's decreased in a lot of instances based on this survey. But what is perhaps a bit alarming is that operation expenses they don't appear to have decreased to the same level as the revenue has. So it says that businesses perhaps haven't been as agile to deal with the situation, and perhaps they don't have that expertise to drill down into certain aspects of their business and work out that turnaround plan. And then heading further across to the right, what's particularly alarming is the number of people that don't know what their situation is. So perhaps sometimes, regardless of a director or a client's expertise, they may just be a bit time poor. There's naturally been a lot of issues to deal with at the moment, so perhaps they haven't been able to deal with the financial aspect of it, which will then manifest itself later on, and I'll talk about that in the next slide. But and then to further emphasise that point, you can see that, well, despite revenue decreasing in a lot of instances, the operating expenses have also been increasing. So you would think that if an expense wasn't fixed in nature and if it was a variable expense, then that would have adjusted along with the revenue. But in fact, expenses seem to be going up along the way. Talking about a case study, so funneling a lot of that information into what might be a typical business going through this COVID situation. One of the key takeaways that I'll emphasise is being proactive will help deal with the situation. There's all too many times that we'll get a call to assist a director and it's at the 11th hour and they're really starved of resources, and just by virtue of its situation, it affects the number of options that are available. So I'll emphasise that being proactive is important, and I'll talk about it in the context of this case study. To explain what insolvency is in the most simplest terms, I've included a green line, which basically depicts available resources. So that could, in accounting terms, be current assets, or it could be funds available in an overdraft. Basically, what assets are at disposal available to then meet the debts that are due. The red line then captures what debts are due. So going through those statistics that I've just talked about, you can see that there's been a lot of revenue pressure on a lot of businesses, and so you can see that while with income dropping, companies have had to reach into their cash reserves to continue looking after the continued trading. And so that's where you can see that, well, in a typical case study where revenue is impacted, it starts to drop off, and then their available resources then suffer because of that. And then one of the benefits during the last 8 to 9 months with the government reform, there's been a lot of financial relief, but there's also been measures where directors of companies have been able to defer liabilities. So we talked earlier about the code of practice for landlords, where some repayments are being deferred. People have been contacting their banks, deferring those repayments, or just negotiating with sympathetic creditors. So unfortunately, what that does is it doesn't extinguish a liability, it just delays it. So where the revenue pressure affects the available resources, the deferred liabilities will then come home to roost at a later date. So that's where you can see the spike in deferred liabilities. And that's, sorry, I'll just finish off on that, Sean. And so what the period that we're entering into now is, as we head to the end of the year and this automatic protection gets lifted, well, that's really thereafter is where those deferred liabilities are going to impact businesses. And that's when a director would want to be thinking about the solvency situation and now proactively thinking about, well, I want to go from one safe harbour to the next safe harbour that's becoming available. And then the other element, just closing off, Sean, is that invariably the earlier a director acts, more runway they've got to then rectify an issue. And so, and the more in control they are. So later on in the piece, when those deferred creditors are really knocking on the door, they'll be at the mercy of the likes of, say, their financier or the ATO. So acting earlier will then give them more strategic options. Yeah. Okay, so what are we seeing in the market? As we were saying earlier, a safe harbour doesn't have to be disclosed to creditors or to the market, not even if it's a listed entity. So it's very secretive, and it makes it a little bit hard to know, you know, what our competitors are doing, perhaps. So what we'll do is we'll offer our direct insight and our experiences. Initially in March, we received a lot of inquiries about safe harbour, and that was while the government was jostling to put their own protection measures in place, and then they put that automatic protection in for directors from insolvent trading. So then it tapered off quite quickly, and now we're starting to see those inquiries lift again, which is, it's not a coincidence that we're doing this session now, because it's highly relevant with that automatic protection lifting at the end of the year. And so the inquiries definitely spiked because you know, your savvy directors are wanting to make sure that they still are afforded that personal protection. And we've talked about who that's relevant to, and then naturally the financial circumstances, the economic conditions have given rise to a lot of businesses that, other than the personal protection, would appreciate an expert helping them through the adverse circumstances. Okay, so what if your plan isn't working? If the plan's not working and you're going through it with a sufficiently experienced advisor, what you'll be doing is you'll be revisiting the plan regularly and methodically, and there's absolutely no reason why it can't be changed or adjusted. As Shaun mentioned, with regularly changing trading conditions, there is every chance that it may need to be adjusted, and a business may need to pivot through it. So if it's not working, there's no reason why it can't be changed. But what if it's not perhaps resulting in the turnaround that's desired? Well, then it could still be working in the sense that it's providing a better outcome for creditors than if the company went into liquidation or administration. So it may still be pursued through that stage. And ultimately, if it's not working, it doesn't mean that the company can't take advantage of other statutory methods of restructuring. So voluntary administration will perhaps be a very prevalent tool to restructure a balance sheet in the next 6 to 12 months. So if a plan's not working, it's not the end of the world. Can be tailored, and even then there is still a plan B and a plan C that can be pursued. FAQs. So, and I might start the FAQs off with, we actually had a question from one of our attendees. The question is, may I ask if the position of the director in regards to inherited debts prior to their appointment as a director. So a director is not necessarily liable for a debt that was incurred prior to their appointment. However, that debt can contribute to a company being insolvent. And so if they take an appointment over an already insolvent company, they then would need to be concerned about debts that they're incurring thereafter. And I say generally it wouldn't apply because there are some debts that can attach to them, such as taxation liabilities, where they get a grace period before that they can then be found liable for taxation liabilities under a director penalty notice. And I'll run through these other FAQs. I'll bounce them off Duncan and Shaun. Is this a formal process that requires a notification to ASIC, such as an appointment as an administrator? I'll start with Shaun, Pat.
Sure, I can take that one. The answer is no, it's not a formal process. This is protection for directors only. You don't have to advise ASIC, you don't have to advise the ASX if you're a listed entity. It's just something that you as directors need to document in circumstances where you require protection in the future if your restructuring efforts don't work.
Yep. And then jumping between the two of you, who can be a appropriately qualified entity to sign off on the plan? Duncan.
Right, mate. Look, the appropriately qualified entity is a bit of a vague term, but practically it's got to be somebody who's experienced in restructuring, insolvency, turnaround. So registered liquidator is your normal person, or somebody who's experienced in advising registered liquidators, so your insolvency lawyers. Those are typically the people who are signing off on or reviewing safe harbour plans and providing an opinion as to whether they've got that likelihood of delivering a better outcome. Next question.
Duncan, I was just going to jump in and say it's probably relevant to note too, isn't it, that in most of the safe harbours that we've been involved in, there's typically a lawyer and an accountant involved along the process. And the reason being is that you need legal advice through that process at times. And there are also some financial advice that you need, especially when it's talking about reviewing financial forecasts that support plans. So ultimately, I think you end up with both an accountant and a lawyer if you want to do it properly.
Yeah, spot on.
Yep. We've already covered off on whether the process has been tested in the courts as yet, which it hasn't been. That perhaps indicates that it's working. I think we're eagerly watching that space because when these sorts of processes are tested in court, it gives us a little bit of clarity around some vague elements of the legislation. Next question: when does safe harbour protection begin?
So safe harbour protection starts from the moment you begin to develop or implement a plan. So my view is that if you as a board determine that you're going to enter safe harbour and you take steps to engage an entity or to help someone develop a plan, or you simply just instruct management to start developing a plan, then safe harbour starts from that point in time. The explanatory memorandum that sits behind the legislation does talk about the fact that you've got to reasonably move forward with that plan pretty quickly. But the protection itself starts from the moment you take action. You got to keep taking action and move along the path, but it starts from when you begin the action.
The next two questions probably come under a similar vein, but what happens if ATO lodgements fall behind, or if a business falls behind in paying their employee entitlements?
Yeah, rightio. Look, if either of those things happen, you've lost the protection. Those are some of the criteria for entering the safe harbour and staying in safe harbour. So the minute you've dropped behind in your ATO lodgements, so you stop paying your employees, you've lost that protection, and you know you're back to being on the hook for insolvent trading.
Yep. And the final question actually ties into the final FAQ is very similar to the question we've just received in our chat room. So does the better outcome test mean that I have to prove I am insolvent, which also ties into one of our guests' questions, which is the better outcome test a specific document for safe harbour protection, or the better outcome could be documents as outcome of a restructuring action plan? So I think what they're talking about is the level of documentation that's required through the process, and then how does that then tie into proving that somebody's actually in fact solvent?
I'll take that one, Matt. So the better outcome test really is only articulated in the legislation to say you need to demonstrate that the course of action that you're taking is reasonably likely to lead to a better outcome than administration or insolvency. There's not a template as such that you have to adhere to. All you need to do is get an appropriately qualified advisor to review your plan and then form a view that it is reasonably likely to lead to that better outcome than administration or liquidation. And the way we think that's done is you need someone to be able to do a proper assessment of what would happen if there was a liquidation or administration today. And that involves typically an assessment or calculation to understand, given the different priorities under the Corps Act, how different creditors would be repaid and whether or not they would recover 100 cents in their dollar. And then compare that to the outcomes of a restructuring plan, which in most circumstances will hopefully demonstrate that through a period of potential insolvent trading, the business can come out the other side if it restructures in a particular way so that everybody receives 100 cents in the dollar or pretty close to. Hopefully that answers the question.
Yep. So just summarising there, that there's no specific document, but best to have, I think we covered off on it earlier, that it's important to have it documented because it's one of the main tests that'll be that could be contested. So to have it documented helps a robust plan. Yep.
All right. So look, I'll just briefly wrap up now. So takeaways that we wanted to leave you with. So directors on this call or advisors to directors, if you're relying on COVID protections or experiencing COVID impacts that are threats to solvency, then the most important thing is you need to be proactive. First of all, understand your risk. So if you're not sure, get somebody that's qualified to understand insolvent trading and do that calculation, do that assessment to understand if you have a risk. If you do think you have a risk as you head up towards the 31st of December when the COVID protections expire, then you really need to be taking steps to put in place a plan that gives you protection past the 1st of January next year. Engage early with appropriately qualified advisors. So talk to your lawyer and talk to an accountant that has experience in insolvency and restructuring related matters. Do that early. They'll be able to guide you through this process in a way that gives you protection where it's available to you. And then use Safe Harbour not just as protection for you as directors, but as a strategy for a turnaround for your business. The great thing about Safe Harbour, we think, is that when it's properly implemented, it actually creates a best practice restructuring environment. And it really gives businesses the best chance of actually trading through difficulties. Because as Matt alluded to earlier, one of the things that frustrates us when we're working with boards and directors and businesses that are in difficulty is that they never come to seek advice early enough. And quite often, when we get to a position where they've come and asked us for help, we see a circumstance where they've just been fighting fires, rather than putting in place a properly structured and documented plan that's supported by advice from independent parties that can maybe take that step back and give you advice based on previous restructuring and turnarounds that they worked on. So look, that's all we wanted to cover today, and I think we're right on time, which is great. Look, obviously, the contact details for both myself, Duncan and Matthew are on the screen, and we've got people from all around the country on today's webinar. If you do have any sort of questions or follow-ups, or you just want to basically pick our brains around whether or not Safe Harbour is relevant, or if you're doing it right, or if you need some help with it, then we'd encourage you to reach out to whichever one of us is in your local jurisdiction. Any of us are happy to get on the phone and just have a conversation to give you some insights if it helps. That being said, that ends our session for today. I won't go through any more questions because we've already done that. So thanks very much, everyone, for your attention today, and we appreciate you participating.
Thank you, everyone.
Thank you.